So,
Okay.
welcome everyone. Thanks for joining us for this Lunch and Learn. I hope you are getting your lunch in still. I'm Heather Pierce. I'm the Workforce Education Program Manager with Waubonsie Community College. And just a little plug about my services. So, I'm within obviously the college, the academic divisions of career and technical education. And my focus is on employability through short term credentials and work-based learning. So, this webinar is brought to you today in partnership with Workforce Education, the Small Business Center, which is run by Harriet Parker. She unfortunately could not make it today because she is consulting with clients, and that is the service that the Small Business Center provides. And in addition to free webinars like today, and our lovely speaker today is Doreen Petty of Doreen Petty Coaching. She's an HR professional that helps small businesses of I cannot say this, Doreen, sustainable success. That's hard.
Yeah.
By HR consulting, operations development, and leadership effectiveness. Doreen specializes in businesses with 0 to 15 employees, and we will share her contact information in our follow-up email. So today's topic obviously is on the new Senate bill, which impacts employers of all sizes. So you're on, Doreen.
As Heather said, we're going to be talking about the new Senate bill. It came in Senate Bill 1480. Always confusing because they reuse the numbers over and over again. So this 1480 is not the same as the 3 year ago 1480. So if anybody tries to search it, you will find plenty of information. And what this bill did was it effectively amended 3 acts in Illinois: the Human Rights Act, the Business Corporation Act, and the Equal Pay Act in Illinois. And it applies the first thing we're going to talk about, the Human Rights Act, applies to every single business with employees in Illinois. The other 2 are obligating large businesses of 100 plus, but the information that they're applying is important to all businesses. So I think that it's worthwhile for small businesses to understand the content and the context of what they're trying to do with the amendments, and see it as our role as small business owners to also pay attention to what's important to individuals in the community and in our employ. So I put a lot of information on the slides, more than you would normally see in a regular presentation. But I wanted you to be able to have this, and everyone's going to get a copy of this slide deck. And so you'll have a little more information than just an outline. And then you'll have my contact information in the follow-up. I apologize for not putting it on the material. But if you have any questions beyond today, you can feel free to send those questions back to me, and I'll be happy to answer them in cooperation with Heather and with Harriet. So we will talk about let me see. Oh, I thought that wasn't going to move for a second. So we've got the Human Rights Act amendment, and what the Human Rights Act amendment has done was basically make it a civil rights violation to use a conviction record against individuals, either employees or applicants, in decisions around employment actions. So no business can base a no hire or any other employment action based on a conviction record. And I see this as an evolution of the ban the box movement, where a big movement that started quite some time ago, years, to remove the conviction record requirement from applications. I know a lot of businesses have already done that. This kind of makes it much more public kind of thing, because in order to do that, if a business wants to decline or make somebody ineligible for some employment action or any employment action, there must be a substantial relationship between the job and the conviction, or there might be a unreasonable risk to people and property as a result of putting somebody in a job. The responsibility for defining what that is to prove that that's the reason is on the employer. And there are actions that need to be taken, that there's guidelines on how to disqualify someone under this. So I'm gonna talk through, and I made some notes, so excuse me if I look down to pull from my notes, but if a business disqualifies a candidate based on the conviction record, the guidelines of notification and mitigation are pretty significant. So, but first I want to tell you what it means to have a substantial relationship between the job and the conviction, or have an unreasonable risk to people or property. So a substantial relationship, when you're looking to determine whether or not to disqualify, what you're going to look for is whether or not the position offers an opportunity for a person previously convicted to repeat that crime or a similar offense, and whether the circumstances leading to the previous conviction may recur in the current situation. A substantial unreasonable risk, employers must consider, you'd be looking at the length of time since the conviction or convictions, the age of the person when it's happened, the number, the nature and severity of the convictions, also its relationship in a general sense to people and property as a risk factor, and also any evidence that might be in play for rehabilitation efforts. So that's going to be looked at, and in general, all of the circumstances surrounding the situation. So if you have a situation that comes up, and this could be an employment decision that's being made, or a promotion decision, a job move, it could be a current employee or somebody new. It doesn't matter. It's any employment action, regardless of the status of the employee or the individual at the time. So if you decide you're going to base an employment decision based on a conviction record, then you must notify that person involved, and the notice must contain the disqualifying conviction, so what is being disqualified, that there's a job or a movement or something like that, and which conviction is being used as a disqualification, and the basis of your explanation of the basis for your decision, as well as a copy of the conviction history if you have it. I'm assuming they're going to make those available. They're not now. So that's going to be an interesting piece. And then when you give them the original disqualification, you have to identify it as a preliminary decision, and you have to give them 5 days to respond to your preliminary decision. And their response can include anything they want to include in there. There's no specifications on that. It's entirely free form. And after the 5 days, and you get a response, and if you decide you're still going to decide to disqualify the person from the employment action, then you have to give them another notice saying that your decision is final to disqualify them from the employment action, why you're choosing to do this, and any additional procedures that you may have as an employer to mitigate or otherwise challenge. So if you have a process for challenging management decisions in your company, then you would apply this process and let them know how that works. And you also have to let them know that they still have a right to file a charge with the Illinois Human Rights Department. So the Department of Human Rights in Illinois. So all of that is pretty complex. And the intent here is to help people who have been convicted, help them access more jobs in the workplace and to retain more jobs in the workplace. And so it does impact all employers. So every employer has to look even before. It's a good idea that even before you're faced with a situation where you're making a decision about disqualifying people, you want to look at your workplace and imagine a situation where you have someone with a conviction that might apply, or maybe you have people who are already carrying conviction histories. Look at that and imagine what it would look like. What would you have to do? What would cause you to disqualify people? What situations and circumstances exist in your business that this might be a conversation you have to have? So rather than wait until it happens, there's nothing wrong with checking it out in your own mind and kind of going through the motions to figure out what that would look like. If you're concerned about that and you'd like to bounce it off of me, you want to have a conversation about that, I'm happy to have those. I'm happy to have those conversations. Everybody gets to talk to me for free at least once, sometimes more. So don't hesitate. And this is effective. I forgot to say this is effective on March 23rd, 2021. So it is effective right now. And it was effective on the day that the governor signed the law. So this is the only one that's effective immediately. That's actually not true. I'm going to talk about whistleblower protections. Those are actually effective now also. So the next piece is the Illinois Business Corporation Act. This one applies to employers with 100 plus employees and federal contractors with 50 plus employees and $50,000 in contracts. And they have to go through the motions and follow the rules on this, but it doesn't change the fact that this is something that we should all be concerned about, because what this is doing effectively is asking businesses to pay attention to what's happening in terms of the view of their employee population versus the view of their community or their talent pool. And even the smallest of the small businesses should be considering how they reflect their communities as far as diversity goes. So what this law does for large employers is that it requires reportable data or diversity data like gender, race, and ethnicity across job categories that are defined by the law. So it's just generic job categories. And these data have to be reported in annual reports. Any annual reports filed after January 1st, 2023 are going to require diversity data. This particular data is very similar to the data that's already reported by these companies in their annual EEO-1 reports. So it's data that they're already collecting, and they're just going to be asked to put it, or required to put it in their annual reports. And the Secretary of State will publish this aggregate data on an annual basis. So the impact to small business is really just a reminder to consider. It's really just a reminder to consider whether or not diversity in your business reflects your community, and if it doesn't, how are you going to address that? So that's also another conversation that that we can have if you would like. So after January 1st, 2023, that's going to be if any of you are getting towards large employment, the bigger you get, the more important it is, probably, because when you're a small employer, it's kind of in your face all the time anyway. You're thinking about it. You're making sure that you are reflecting your community. As you get larger, your processes and policies might change. You've got more people involved with it. It's a little bit harder to take a handle on it. So anything that you do now to plan your strategy around diversity representation is a good thing. So the next one is the Illinois Equal Pay Act. This one gets a little bit more complex because this one is also requiring large businesses to do certain things, but it also has the side benefit of small businesses should be concerned about equal pay as well, because you're still obligated under other equal pay requirements at the federal level. And if you're not required based on the number of employees you have, there certainly is still, again, a community-based expectation that we should be, as small business owners, we should be paying attention to equal pay. And so if nothing else, this new law shines a light on what might be true about equal pay. So here's what's going to happen for large employers. They have to apply for and be awarded a certificate that is called an equal pay registration certificate. And they have to pay a fee to even apply for the certificate. And they have to submit what they're calling an equal pay compliance report. And that is a report that sets out how pay is set in the business. So there are lots of different approaches to setting pay strategy or putting a strategy in place for payroll. Market pricing, prevailing wage, union contract requirements, performance-based pay systems. There could be internal analyses. There could be a process of checking current pay in job boards and at the Bureau of Labor Statistics or salary.com. And everybody has a lot of different ways to do it. And large businesses will have to explain that in this report. And then they also have to submit their most recent copy of EEO reports because there's some information there that's relevant. And then they also have to report the total wages paid to each employee during the past calendar year. So you can imagine how complex this will be. The larger the business, the more complex this process is. So this certificate is not required until March 23rd of 2024. But it's going to take a while for business, especially the large businesses, to pull all this data together. That's why it's delayed out, and it's a 2-year renewal process. So once they receive their certification, they will have information that kind of certifies them in compliance with Title VII of the Civil Rights Act and the 1963 Equal Pay Act at the federal level, plus the Illinois Human Rights Act, the Equal Wage Act in Illinois, or Equal Wage Act in, there's also a couple of other laws on there. I didn't clarify that, but also then the Illinois Equal Pay Act. They will also, and part of the reason why they're asking for actual wage data is because they're going to be certified. They're going to look to make sure that the average compensation for females and minorities is not consistently below the average compensation for males and non-minorities. And also that employment decisions are not made based on gender or other restricted class information, and job classifications are not restricted by gender or other protected class as we move into the meat of the data. So businesses must maintain consistent and periodic evaluations of their compensation strategy and their benefit strategies to ensure that they remain compliant with the laws. And if for some reason disparities do pop up, they have to be able to show that they correct them promptly. Now, I'm assuming by that language of the law, they're going to eventually start collecting the disparity information when it comes up. And I'm not sure exactly how that's going to happen, or if it's only going to be collected based on charges to the Equal Pay Act, but we're going to learn more about that, and whether or not it remains an issue for 100 plus employees is also up in the air, because this is something that's been a conversation for businesses of all sizes. to make sure that equal pay is enforced and businesses are made accountable. There's a lot of movement to make businesses accountable of all sizes to make sure that equal pay is a consideration. So this is an opportunity for small businesses to step up and look at the compensation strategy. So even the smallest businesses can have a compensation strategy rather than just okay, here's the dollar amount I pay. It's way more than just the difference between minimum wage and what other people are paying and how do we know what we know. There's a little bit more to that, and this is an opportunity for small businesses to step up and get more aware of how they set salaries and to make sure that they are not inadvertently creating some kind of discrimination in compensation and benefits as a result of their practices. So there is a penalty for this for large businesses. If they fail to be in compliance with this rule of law, the penalty can be 1%, up to 1% of gross profits. They didn't specifically say, but I'm assuming that means in a year. So it can be pretty significant. And there's also no language that talks about whether or not this is a rolling penalty or if it's charged at a particular time with an evaluation. So it doesn't apply to small businesses, but this information is important, as I said, with small businesses because frankly, small businesses are the heart and soul of the economy in this country. And we should be paying attention to equity, to diversity, to how we manage our people, because this is how the economy marches. And small businesses have quite a lot of power in the economy from this, and there are other laws that are going to apply. If you have one person, there's equal rights, maybe you have 15 or 25 different laws apply at different sizes. So simply being aware and doing the right thing without having a law behind it is also possible for small businesses. And we have the power to manage this for ourselves. So with the Illinois Equal Pay Act, there's also some new whistleblower anti-retaliation protections. So this is kind of clarifying some of the whistleblower stuff that already exists at the federal level and bringing it into the state level. So this prohibits, this is a little complex in the language, but I use the language specifically to make sure we're not missing anything, that this prohibits employers from taking any kind of retaliatory action against employees who engage in certain behaviors related to exposing or threatening to expose various activities. So like if there's a policy, a practice, a lack of action, or some kind of positive action that an employee believes is a violation of a rule of law or some kind of regulation, if an employee provides information or testifies before any public body also related to, maybe there's an investigation, a hearing, some kind of practice that that maybe somebody's already been, there's an inquiry of a violation of law or rule or regulation specifically by nursing home administrators. So they're calling out very specifically nursing home administration, because if you've been following the news the last few years, this is an issue. So that one is specific, but also if an employee assists or participates in a proceeding to enforce the Illinois Equal Pay Act rules, there can be no retaliation for that. If an employee claims retaliation, they must be able to show that whatever their protected activity was, their alleged protected activity as a whistleblower, was a contributing factor in the retaliation meted out by their employer. The employer can counter that and avoid liability if it can effectively demonstrate that it would have taken whatever adverse action was taken regardless of whether or not the whistleblower action took place. What that looks like is we don't know because it's going to have to be tested. So there is some case law already in play on whistleblower actions at the federal level and in other states. So it'll be interesting to see. This is going to be tested in the courts over time, and it can, we'll see what that looks like. And it affects everybody. So this is the situation. This does not just affect large employers. Whistleblower protections can apply to everybody. I would expect that we're going to see more specificity around that in the language of the law as we move forward and as it gets tested. So any employee that successfully argues that they have been retaliated against because of protected whistleblower activity can be awarded double back pay plus interest. They can be awarded reinstatement to a job that was lost because of retaliation, and they can be awarded reasonable attorney's fees and other costs that might be involved with that. So it's really clarifies the protections under Whistleblower Act and brings it into Illinois as a very specific rule of law for the Illinois Equal Pay Act. But I would expect that this is going to find its way for the clarity of this and the language of this, I expect is going to be spread around. We're going to see it more often. We're going to see more states picking it up. It's going to be an interesting thing to watch for those of us in the HR community. So excuse me if I get excited about this stuff because I think it's important. Okay, so let me summarize. So this bill, 1480, Senate Bill 1480 was signed into law on March 23rd, 2021. It amends the Human Rights Act, it amends the Illinois Business Corporation Act, and it amends the Illinois Equal Pay Act. All businesses must immediately avoid making decisions for employment actions solely based on conviction history. And if you make a decision to do that, it has to be based on a substantial relationship between the job and the conviction, or a substantial expectation of risk to people or property, because the situation of the employer's situation or employment provides an opportunity to repeat past crimes. Large employers and some federal contractors will begin putting EEO data in their annual reports beginning in 2023. And by March 23-24, large employers must apply for and qualify for a certification that proves that they are in compliance with various laws around equal pay, and that they will prohibit discrimination based on gender, race, and other protected classes. Plus, the whistleblower protections in Illinois have been clarified with information about prohibited activities and penalties for retaliation. So that is exactly how long I thought it would take. So does anyone have any? Yeah, that's awesome. So does anybody have any questions or comments? Did everybody get to eat their lunch? And I'll apologize in advance if everybody was just kind of bored through the whole piece of information. This stuff excites me, but I can understand why it might not be exciting to other people. So what do we hear?
I think it's just heavy. It needs to marinate a bit.
and I think it needs to be. I think because this is a law because there have been problems with these things in the past. And the fact that they've been packaged together matters too, because what they're basically saying is all business owners in Illinois need to step up and take responsibility for improving the treatment of people with convictions and helping people have access to a job and a lifestyle, and also for equal pay, to make sure that all business owners step up and say, yeah, we need to make sure that we're not inadvertently discriminating against people for reasons that might have been set in in habit or history. Years ago, I worked with a retail client that just by matter of course, over 40 years in the retail establishment, this person had gotten into the habit of paying single people more than married people, because the owner believed that with married people, they were bringing in more than one income. So he could save some money, right? And in his mind, it seemed very reasonable over the years, but then it crossed the line, and of course it was no longer reasonable. It had not been for a long time, and we fixed it, and it turned out that the compensation impact really wasn't as great as one would think, and his spending wasn't really any different because it was also very generous with bonuses. So in the end, it really didn't make a thing, but it was still an example of a situation that should not have occurred. So we just don't know until we hold up the mirror to ourselves and look at what we're doing.
Thank you everyone for your time today, and I hope you enjoy your lunch or you enjoyed your lunch. Thank you.
Okay, great. Thank you, everybody. Have fun, and reach out if you have any questions.